114506, State of Kansas v. Sarah Gonzalez McGlynn.
May it please the Court, Sam Shire of the Kansas Appellate Defender Office appearing on behalf of the defendant appellant, Sarah Gonzalez McGlynn. Your Honor, may I please reserve 3 minutes of rebuttal argument?
3 minutes is granted.
Thank you, Your Honor. To briefly state the facts for the audience, in January of 2014, Ms. McGlynn did kill Harold Sasko, the victim in this case. Trial evidence showed that Mr. Sasko was sedated with sleeping pills and then administered a stab wound in the neck that very quickly caused his death. In the briefs, both counsel discussed the relationship between Mr. Sasko and Ms. McGlynn. I think for the purposes of argument today, it suffices to say that in our view, there were disturbing aspects to that relationship. At trial, Ms. McGlynn presented a defense of mental disease or defect. To further that defense, an expert witness testified that Ms. McGlynn had a dissociative identity disorder condition. Essentially, that meant that Ms. McGlynn's psyche was fragmented into multiple personality states that did not have consistent thought processes. At the close of trial evidence, a jury convicted Ms. McGlynn of first-degree premeditated murder. Subsequently, the jury returned a verdict indicating that the offense was especially heinous, atrocious, or cruel. Those verdicts permitted the district court to impose a hard 50 life sentence, and Ms. McGlynn appealed from her conviction and sentence. Moving to the legal issues presented by this appeal, unless this court desires otherwise, I'd like to start with the first two instructional issues raised in the brief and then move on to the hard 50 issues. So moving on to the first issue, we believe that the district court erred by not instructing the jury on second-degree intentional murder. I don't think that there's any dispute between the parties that second-degree intentional is a lesser-included offense of first-degree premeditated. So at least with respect to error, I think the only question before this court is whether trial evidence warranted an instruction on second-degree intentional. And it's our belief that in every first-degree premeditated murder trial, it is appropriate for the district court to instruct on second-degree intentional murder.
Do you think that's required, regardless of the evidence?
Yes, I do, Your Honor.
Just automatically, there, in any premeditated first-degree murder case, irrespective of the case law and of the statute, a requirement is that second-degree intentional should be given.
Yes, Your Honor.
Because in this case, there was certainly not an absence of any kind of premeditation.
Well, I believe that the mental disease or defect did cut to the element of premeditation and would allow a jury to find that this was a non-premeditated offense. But just as a purely legal question, I think this court's test for determining whether it's appropriate to give a lesser is whether trial evidence would support a conviction on that charge. In other words, if it were challenged on sufficiency grounds on appeal, whether it would be upheld or not. And obviously, if the district court would have instructed on second-degree intentional, sufficient evidence would have supported a conviction on that count. So we believe that it was appropriate to instruct in this case.
But why should we be firmly convinced this is under the clearly erroneous?
Yes, Your Honor.
And so we have to be firmly convinced that the jury would have opted for second degree.
Yes, Your Honor.
That's a pretty big hurdle for you to leap.
Well, Your Honor, I think we've met that burden in this case because of the expert witness testimony that was given. Dr. Hutchinson testified that Ms. McGlynn had a DID condition that prevented her from achieving rational thought processes at the time of Mr. Sasko's death. And we believe that premeditation does require rational reflection on the act of killing.
Independent from what's required to show intent. I mean, premeditation isn't just a timing thing as much as it is a state of mind.
I don't think it's just a timing thing, Your Honor, because this court's case law, I believe, indicates that there is no specific timing aspect to premeditation, and it refers more to a defendant's reflection upon the act of intentional killing. A defendant can act intentionally, but without premeditation for a prolonged period of time. So we believe that because premeditation requires higher thought processes, more reflection, more rational reflection than does intent, a jury very likely would have convicted on second-degree intentional, given Dr. Hutchinson's testimony.
So let me just see if I understand. If we accept that that it actually implicates mental state because it requires reflection, so that's a step beyond mere intention to do an act. If we accept that, so your argument is because of the testimony of the expert, because an aspect of this individual clearly could premeditate, plan. I mean, there's abundant evidence of planning and premeditation by an aspect or a personality state of this person. Because it's not true of other personality states, then you are absolutely entitled to the instruction, and it was not harmless to refuse it, or not to fail to give it, I guess is what happened here, right? We're clearly erroneous.
Yeah, I do believe that it is clearly erroneous, because I don't think if somebody's personality state is divided, as was Ms. McGlynn's in this case, that it can be said that their actions are rationally decided. I believe the testimony from Dr. Hutchinson, was actually that the personality states were not even united in their desire to bring about Mr. Sasko's death.
What do we do with the mental defect defense statute that defines that defense in terms of culpable mental states, and then the statute defining culpable mental states does not include premeditation?
Well, Your Honor, I think premeditation by this court's case law is a mental state. And I would note that in
But that's different than a culpable mental state. That's a technical term.
I guess I don't take as narrow a reading of the statute as that, Your Honor. And I think State v. White would support our position that a mental disease or defect defense applies both to the burden of proving intent and premeditation. And with that, I'll move on to the second issue in the brief very briefly. The district court in this case gave a mental disease or defect instruction that applied exclusively to the state's burden of proving intentional conduct. We believe that that instruction was at best incomplete and therefore erroneous. Because again, in State v. White, this court's analysis in that case indicated that a mental disease or defect defense applies both to the state's burden of proving intentional conduct and premeditation. So essentially, the jury, in our view, was not given an avenue to find that mental disease or defect prevented the jury from, was not given an avenue to find not guilty of premeditated murder based on the fact that a mental disease or defect prevented Ms. McGlynn from premeditating. Unless this court has any further questions on the jury trial issues.
Let me just clarify. You're not saying that the instruction was, as given, was necessarily wrong. It was just incomplete.
Well, I believe it was wrong because it was incomplete, Your Honor.
Okay.
And what would have completed it? What specifically would have allowed this to properly get before the jury to provide that avenue in your perspective?
In my perspective, there needed to be an additional sentence saying that it also applied to the state's burden of proving premeditation. The instruction as given stated that it applied to the state's burden of proving intentional conduct. No reference at all was made to premeditation. Moving on to the hard 50 issues, I'd like to start with the sufficiency of the evidence issue. And in our view, insufficient evidence supported the jury's finding that this was an especially heinous, atrocious, or cruel offense. The trial evidence indicated that Mr. Sasko had no knowledge before the time of his death. That death was impending. He was sedated prior to his death. Death occurred very quickly. This was not a long drawn-out offense. And there was not even trial evidence indicating that Mr. Sasko was necessarily even able to feel pain at the time of his death. And what I would not argue to this court is that this was a humane killing, because I don't think that such a thing exists. But what I would argue is that by statute, only especially heinous, atrocious, or cruel killings permit for imposition of a hard 50 sentence, at least at the time this offense was committed. And I don't see anything presented by the facts of this case that adversely distinguish it from a typical first-degree premeditated murder, particularly when it's compared against the facts of State versus Baker. In Baker, a defendant walked into the residence of a victim who was bedridden and suffered from cerebral palsy. The victim was in a totally defenseless state when the defendant shot the victim at point-blank range in the forehead. I think that, and this court held that there was not sufficient evidence to support a finding of especially heinous, atrocious, or cruel. If we look at the facts of that case, I don't see anything that adversely distinguishes Ms. McLean's circumstances from the circumstances present in Baker.
Well, in Baker, we had to speculate. There was no evidence of exactly what occurred at the time of the shooting. There was completely void. Here we have not only your client's version of what occurred, but also some evidence that Mr. Sasko was gasping for breath, that he was conscious. At least there's some evidence to support that fact at the time the fatal stabbing was inflicted. So there is a distinction here between Baker and this case, at least as I see it. Baker required us to speculate about what was happening. Here, where there's clear evidence about how specifically the murder occurred, and some evidence of his, at least some consciousness.
Well, Your Honor,
Pretty significant difference, I think.
well, I agree with you that this case requires less speculation. However, I would disagree with the characterization that Mr. Sasko, the evidence supports a finding that Mr. Sasko reobtained consciousness prior to his death. I'm not sure that that's supported by the record. I know there's statements indicating that he at one point did move, but I'm not sure there's evidence indicating that he reobtained consciousness. And I don't think that there's anything from the record that would support a finding that Mr. Sasko had any knowledge of his impending death. So with that being the case, I think this case is very much like Baker. The only other thing I would note is in its brief, and I do see that I'm out of time at this point, if I could
Proceed.
Thank you, Your Honor. The state in its brief argues that because this was a planned offense, that it can qualify as especially heinous, atrocious, or cruel. I don't believe that that's the case, because while planning is not necessarily required in this state to prove premeditation, I still think the typical premeditated murder offense, what we think about when we think about premeditated murder offenses is planning. And so for that reason, we would ask this court to vacate Ms. McLean's sentence. Unless this court has any further questions, I am prepared to conclude my initial argument at this time.
Any further questions? Thank you, counsel.
Good morning, Charles Branson for the state of Kansas. Unless the court directs otherwise, the state would respond in accordance with the pattern that the defense appeared here. Whether or not the jury instruction was required for second-degree murder. Quite simply, the state would agree that legally, second-degree murder obviously is a lesser included of first-degree murder. However, factually, the state would contend that the instruction was inappropriate in this case. The appellate concedes that this was an intentional act. The testimony at the trial was such that the personality of Sarah Gonzalez McGlynn desired to bring about the death of Harold Sasko. The testimony of the expert, the defense expert at the trial, was that she premeditated it and intended to carry it out, but because there's some dysfunction in her personality that she was unable to form some type of rational thought. It's contrary to the defense's case, frankly, in this particular fact circumstance, to present the jury with a intentional second-degree murder instruction because the defense was not seeking that type of outcome. They really did an all-or-nothing type of defense in this case. The court asked...
Counsel?
Yes.
But we've said, regardless of whether it's sought or not, the court has an obligation to instruct unless the evidence excludes.
Your Honor, and I
instruction.
believe...
I think that's the language we've used in a few cases recently, at least. And I acknowledge some lack of clarity, perhaps, in the body of cases total. But that's the language we've been using recently, unless it excludes. How does the evidence exclude second-degree intentional here?
Well, I believe the evidence in this particular case excludes it because the nature of the defense that has been presented in the case. It's not that there wasn't an intentional act here to bring about the killing. It's not that there wasn't premeditation to bring about the death of Harold Sasko. It was the fact that the defense was seeking to prevent a conviction in this case based upon the fact that their client could not intend or form the rational thoughts necessary to intend. It was contrary to the defense's proposition in this case in the sense that if they would seek a intentional second degree, then it would run against the fact that they were unable to intend the murder at all.
Well,
But,
go ahead.
but didn't Dr. Hutchinson draw a line between the ability to form intent and the ability to premeditate? So couldn't the jury have accepted that testimony and concluded that there wasn't a duty to, or there was an ability to intend, but not a sufficient rational, consistent thought process to have carried out premeditation as you went through different personalities?
Well, if you look closely at Dr. Hutchinson's testimony, she does mention the premeditation portion somewhat inartfully as she's discussing intent. She goes along and at the very outset says that the defendant could not form intent, discusses premeditation in the sense of malice of forethought and that type of thing. But she discusses it in a way that it's clear that intent was the theory that they were operating under.
And do we make that determination? I mean, that's the whole point here. Does the court decide whether the defense has or the state has proved premeditation, and whether the defense expert has negated that particular element? Isn't it the jury that gets to decide each and every element? And when you disallow a second degree lesser, you basically said as a matter of law there was premeditation.
If I understand the court's...
Well, you remember the case where the holding by the Court of Appeals, I think, was that a through-and-through bullet wound was extreme bodily injury as a matter of law, and we said no. That is an element for the jury to decide, even though we may all agree it's an element for the jury. Why is it different with premeditation? Why don't we let the jury decide? If there's overwhelming evidence, then trust the jury to find premeditation. So I'm asking you why that isn't a jury determination rather than an appellate court determination.
Well, it is a jury determination, and the jury was allowed to determine whether or not there was premeditation in this case by being offered first-degree murder, having to find that the homicide was committed with premeditation and intentionally. That was absolutely up to the jury to decide.
And if they had decided it was second degree, we couldn't overturn that as being an improper conviction, could we? Because there was sufficient evidence to support a second degree conviction.
There would be sufficient evidence under that theory, yes, Judge. Yes, sir.
And I'm having a little trouble understanding as to the defense expert. I think what I heard you say is that she was focused on demonstrating that there was insufficient faculties or a mental disease or defect that prevented a forming of intention, right? Is that what you just said? Okay, that's what I understood you to say. And isn't that a defense to both first-degree premeditated murder and second-degree intentional murder? So how did the adoption of the defense and the evidence in support of it preclude a jury finding second-degree intentional? That's what I'm trying to get you to focus on, because we formulated the test a few different ways in different cases, but I think there's recent consistency on this idea that the evidence before the jury must exclude the lesser included before we can say confidently that it should not have been given. And I'm not talking about harmlessness yet. I think you've got an argument there, but let's talk about error.
Okay. Well, it's the state's contention that the factual circumstances that were presented to the jury in this particular instance, even coupled with the defense's expert testimony, and more especially coupled with the defense's expert testimony, really does exclude the intentional second-degree charge.
Is that because the state takes the position that mental disease or defect is unavailable as a matter of law to negate premeditation? Is that the state's position?
No, that is not the state's position, because I think after reviewing White, I think it's instructive that premeditation or that the culpable state could go to premeditation.
Well, if that's the case, then I just return to some of the questions my colleagues have already asked. If premeditation from the state's perspective can be negated as a matter of law, then why doesn't the defense's expert's testimony negate it as a question of fact for the jury?
I'm not completely following your question.
Well, we have expert testimony from the defense that says the element of premeditation was negated by a mental disease or defect.
Right.
And why doesn't that go to the jury? The only reason in my mind that perhaps it might not go to the jury is if that is a legally unavailable defense. But you've just told me it's legally available. So why shouldn't the jury get to decide?
Well, if I understand your question correctly, you're making that application to premeditation, and the jury does get to decide premeditation in this case. The question is whether or not the instruction for second-degree intentional was factually appropriate in this case, and we believe the evidence presented at trial was such that it was not factually appropriate based upon the premeditation that went into the planning and preparation for the killing of Harold Tasco. Because of that preparation and planning that went into that killing, because of the nature of the defense, this defense's expert testimony that there was not the rational thought process available to the defendant to be able to make that intent, that is the only question that really matters in this particular situation. Was the jury able to decide on premeditation? Absolutely, and certainly they were. Were they able to decide on intentional? Yes, they certainly were, because that was part of that instruction.
But they couldn't decide between the two. They did not have the option to pick one or the other. And that's the issue.
Right. But I think under the factual circumstances, the nature of the case and the way it was presented to the jury, they should not have been able to pick between one or the other, because it was a situation where the defense was indicating that it didn't matter what was before them, the defendant was unable to form this intent. Premeditation essentially was conceded in this case. The planning was overwhelming.
And if that's the case, if premeditation, let's just say it was, or let's accept that premeditation was essentially conceded by somebody,
Right.
then doesn't that bring it all down to intent? And isn't intentional second-degree murder, isn't that all that it requires, is intent? And if that's what they were arguing about, shouldn't they have had a choice to convict on second-degree intentional? If that's what the whole case was about, whether there was intent, I just don't understand how advancing a defense of mental disease or defect makes intentional second-degree murder impossible as a matter of law, which is what you're arguing when you say there was no error.
I do not think it makes it impossible, I suppose, as a matter of law, but the defense did not seek the instruction.
Right. So we're
But I
clearly
think that
erroneous.
was, I'm sorry.
So clearly erroneous is our standard for reversal.
Right.
And that, of course, lessens your burden on harmlessness.
But I think the defense also has the ability to apply the strategy that they wish to proceed with in the case. I think it muddles the case if
But we've
from the
said that's
defense's-
not true. We've said that a defendant doesn't get to choose an all or nothing. I mean, you're preaching to the choir here. I think that the attorneys ought to be able to try their own case, but our precedent doesn't back you up that a defendant gets to control that, to have no lessers. Would you agree?
I would agree that's
Yeah.
standard.
Counsel, my understanding of your opponent's argument is that in every case of a charge of first-degree premeditated murder, automatically the jury should be instructed on second-degree intentional. And I hear you saying several times today, but in this case, such an instruction is not factually appropriate. And I just want to make sure I'm understanding that particular argument. Are you saying that this instruction should not have been given because no jury would have returned a verdict of second-degree intentional murder on these facts and on the defendant's theory? Is that what you're saying?
I think under the way the case was factually presented in court to the jury, I think that no jury would find that intentional second-degree murder without premeditation was appropriate.
And that's principally because the evidence of premeditation was overwhelming.
The evidence of premeditation was overwhelming and I believe essentially uncontested at the trial. There's a short amount of time left. Is there a topic that the court would like for me to address before I retire?
Well, speak to your, what's your position on the especially cruel and heinous, the hard 50? I think I know your position, but could you articulate it in response to counsel's?
Yes, the especially heinous and atrocious. Quite frankly, the manner in which this homicide was carried out was the especially heinous, atrocious, and cruel. It's not just that the fact of the matter was planned or premeditated in advance. It was the fact that it was, I think, clearly distinguishable from the facts in the Baker case, in the sense of the person went in and, yes, murdered a helpless individual. But the planning and the method and manner in which this case was carried out, the cold calculatedness of drugging the victim, binding the victim. When the victim started to come around, they attempted to unbind and change their mind and rebound the victim, finding the carotid artery, not simply just stabbing the victim to death, but literally bleeding the victim as you would an animal by stabbing the victim in the throat at the carotid artery, and not just simply taking the knife out, but then sawing through the rest of the neck, nearly decapitating the individual. The manner that this homicide was carried out in and of itself, is the evidence necessary for the jury to find that it was heinous, atrocious, cruel.
In other words, you can have an especially heinous, atrocious, and cruel murder because someone stabs wildly and you have a very bloody scene, and something like that can be especially heinous, atrocious, and cruel, but cool calculation, clinical approach can also satisfy it. That's your argument.
Yeah, simply put, just because a homicide scene is messy doesn't
Right.
fit the bill.
Got it.
But as the court reiterated, the manner in which it's carried out really does, in this particular instance, make it heinous, atrocious, and cruel because of the calculation, the planning, and the methods that were used.
Any further questions? Counsel, we took up a lot of your time with our questions. Did you want 30 seconds to wrap up, or do you believe you've made your points?
Your Honor, I believe I made my points. The state would rest on its brief. We'd ask the court to uphold the conviction. Thank you.
I'm sorry, may I ask one more question?
Yes,
You
ma'am.
didn't get an opportunity to talk about harmlessness on the second degree intentional instruction, and I just want to hear what you have to say about that before you say.
Just briefly as possible, I think we've kind of approached it a little bit. The court would have to find clear error under these circumstances, and to that end, the evidence was so overwhelming in this case of premeditation that the defendant practiced killing with a knife by cutting the throat of an animal, searched the internet for terms associated with killing, incapacitation, and flight, told her employer that there was a death in the family and she'd need time off to provide a cover for her whereabouts, procured and crushed up the sleeping pills, placed them in the victim's beverage so the victim wouldn't detect it, bound his hands and feet with zip ties. After the killing was completed, left her cell phone and her vehicle behind so she would not be detected, took cash and valuables to sell while she fled across the country. The overwhelming evidence in this case of premeditation is such that there's very little chance that this court should be firmly convinced that it would make a difference in this case.
There was also some evidence, was there not, undercutting the effects of the malady? In other words, I think the not only, of course, did defense experts support the existence of the DID, but this expert for the state acknowledged that, in fact, she might suffer from that condition. Isn't that right? But there was other evidence undercutting what effect it may have had, the possibility of malingering or exaggeration.
Correct. There was testimony on cross-examination, direct examination, that there was malingering evidence by the testing. In fact, one of the testing instruments was deemed to be invalid because of that. The state's expert, Dr. Logan, after evaluation, came to the conclusion that she could have DID, that certainly after her sessions with Dr. Hutchinson, that she believed that she had DID, but did not exhibit any of the traditional hallmarks of DID, which include things such as when one personality takes over, that the other personalities are not able to tell you what that personality did. In this particular instance, she had clear understanding and clear recall of all the events leading up to, during, and after the attack on Mr. Sasko. So that coupled with the premeditation and planning of it, I think there's very little opportunity for the court to be firmly convinced that this made a difference in the case.
Any further questions? Thank you, counsel.
Thank you.
May it please the court. Unless this court desires otherwise, I'd like to go ahead and keep moving on the Hart 50 sentencing issues. And particularly during deliberation in the Hart 50 proceeding, the jury asked the district court for definitions of the term heinous, atrocious, and cruel. The district court did not give a definition, instead, I believe, instructing the jury that words are to be given their common meaning. The district court gave that response in part because it believed that the terms heinous, atrocious, and cruel were not defined in PIC. As we note in our brief, the district court was simply mistaken in that belief. PIC, at the time of this trial, and to this day, I believe, includes definitions of the terms heinous, atrocious, and cruel. And I believe it provides such terms because they have been long established by this court, going back to case law dating to Bailey and Willis.
Have they always been defined the same way in PIC?
Have they all? I'm not. You mean the actual terms heinous, atrocious, and cruel?
It seems to me like I saw somewhere that prior to 1999 there were some different definitions.
Yeah, prior.
And my question would be is if we've defined them differently, how could they have a common meaning for the layperson if they don't have a common meaning for the legal community?
I think that's correct, Your Honor. I think what the jury is indicating with its question is that it needs assistance in determining what these terms mean. And United States Supreme Court case law, I think, very clearly indicates that these words do not in and of themselves have a common meaning which is understood to an ordinary person.
Go ahead. I didn't mean to interrupt.
Pardon me, Your Honor. But simply just to wrap up, I think the district court should have given the instructions in PIC to clarify to the jury what heinous, atrocious, and cruel mean.
You indicated that you thought PIC defined these at the time of the trial. What edition are you relying on of PIC? Because
Fourth
I think
edition,
the
Your Honor.
2013 edition did not have definitions.
The site that I have is PIC 4th edition, 54.113. And I believe that the definitions in the PIC book that I looked up, those are present. And again, just to wrap up, I don't think there's sufficient evidence to support a heinous, atrocious, or cruel finding in this case. I think if this court disagrees on that point, I think it would still be compelled to recognize that the jury's verdict could have gone either way in this case. So we would ask this court to find that the error in responding to the jury was not harmless. Unless this court has any further questions, I am prepared to...
So as we understand the means of this killing, of this murder, you don't think the manner in which it was done, just given the facts of what was before the jury, was especially heinous, atrocious, or cruel? I thought your position was that there was no evidence that Mr. Sasko was conscious and aware of what was going on, and that's the distinction you were making. Even if he was, it was not especially heinous or cruel. Is that the means in which this murder took place wouldn't fit factually?
Well, if I'm understanding Your Honor's question correctly, I think if Mr. Sasko was conscious at the time of this offense, which I don't believe the evidence showed.
I'm not sure that makes a difference, but go ahead.
But if he was conscious and was aware that his death was impending, that would support a heinous, atrocious, or cruel finding. I don't think that's what the trial evidence in this case showed.
If we agree with you on the sentencing issue, just for the benefit of our audience, can you tell us what you're asking us to do?
Yes, Your Honor. We would be asking this court to vacate Ms. McGlynn's life sentence without the possibility of parole for 50-year sentence. If this court agreed with the sufficiency argument, then the case would simply be remanded to the district court for imposition of a hard 25 sentence. If this court agreed with the response to the jury question issue, the case would be remanded for a new dispositional hearing, should the state continue to desire to seek a hard 50 sentence.
Very well. Any further questions? Thank you, counsel. Thank both of you for your arguments this morning. Court will take this matter under advisement.